Welcome, everyone. My name is Naja Bullock, and I'm a staff attorney here with King County Superior Court. And right now, in this family law orientation series of videos, we're going to be talking about another important court deadline, which is preparing for trial. Your trial is the final deadline on your case schedule. And so we'll talk about sort of what that means and kind of the steps that are entailed in that process with respect to preparing for trial. Just keep in mind that we're going to cover a lot of content in this video. The expectation is not to know everything in this video, but rather the goal at least is to provide you information about where you can obtain documents and speak with a live human being if you have some questions with respect to the information that we cover in this video today. So let's get started. So in terms of preparing for trial, this video is helpful just to give you an expectation of what's involved at the trial stage. Your trial is on your case schedule deadline. And here in family court in King County, trials are typically scheduled about 11 months from the date of filing. However, every case doesn't resolve at a trial. Some cases are able to finalize before the trial date. And two ways that you're able to do that are either by agreement, where all parties agree to everything that is either requested in the petition, or they've come to an agreement on everything that they want to agree to in the divorce case or the parenting plan case, or a case can finalize before trial by default. We have videos with links below in the YouTube series for how to finalize by agreement and how to finalize by default. So be sure to check out those videos if you think you may be in those camps with respect to finalizing by agreement or finalizing by default. One more note about finalizing either by agreement or default is that we suggest that you try to finalize your case either by agreement if possible or default at least a month before your trial date, because as you'll see when you watch this video, there's going to be a lot of deadlines that will occur about a month onward, or a month from your trial date, I should say. So try to get ahead of things if you can reach an agreement or finalize by default, and check out those videos to do that. Now, the first question is really, what is a trial? As I mentioned, every case doesn't finalize in a trial, but what is a trial, or what does the court mean by a trial? So at trial, parties give evidence to support what they are requesting in the case. And evidence is typically documents or testimony, someone speaking to the judge in an open courtroom on the trial date, so testimony that gives the court some information about the decisions that the court, has to make with respect to the case. After hearing the evidence in the case, the judge will make a final determination or a final decision, really determining who gets what they are requesting, or whether or not the other party should not get what they are requesting in the case. So examples of some requests are, for instance, if someone has filed a divorce case and a person is asking for spousal support or alimony or maintenance, if you've heard that term. Or another example of a request is a request for a parenting plan with restrictions, or money from a bank account, or a restraining order. For more information about types of requests, definitely check out our evidence video, our discovery video, which goes a little bit more in detail about types of evidence that people can offer to the court to aid a judge in making his or her decision at the end of trial. Now, how do you prepare for trial? And we'll discuss each of the topics that you see on the screen in turn. But in terms of an overview, you prepare for trial by completing your trial materials. And your trial materials are typically the documents that the court or a judge requires of you to aid that judge, to help that judge in making a decision in the case. Another step after completing those forms are serving those trial materials to all parties in the case. And then finally, in terms of preparation for trial, you'll give those trial materials that you've prepared and served upon the other party to the judge, so they actually know what you are asking for. One thing to keep in mind is that the judge cannot automatically pull the information or does not automatically know in advance what the parties want that judge to consider. And so that's why it's required that the parties themselves complete certain forms. We'll go into this in more detail, serve those forms to one another, the parties in the case, and then give those forms that they want the judge to look at trial so that the judge doesn't have to guess what it is you want him or her to look at while considering your request. And most importantly, there are deadlines in your case schedule for completing each of these steps. So all cases with children should have a pretrial conference. We'll talk a little bit more about what is a pretrial conference in a second here. Some cases without children, so meaning in a divorce case or legal separation where there's no minor kids under the age of 18, some of those cases, a judge may have a pretrial conference in that type of case as well. The order on a pretrial conference is going to be developed by your assigned judge or the judge that's assigned to your case per the case schedule. Each judge has a different preference on how they want to receive the forms or what forms they want you to give them to aid them in making a decision at their trial. So for assistance understanding your pretrial conference order, which will be the document that details what forms you need to give to your judge by deadlines prior to the trial date, check with the family law facilitator for some information about that, or give them your case number when you're meeting with them so they can access that information from the court file. You can also do that yourself in terms of accessing that information from the court file, but the family law facilitators can also aid you or point you in the right direction of knowing what your pretrial conference order is, if one's been issued, and sort of giving you general information about what it says based on what the judge has asked you to complete. There's going to be a link in the description box below this video on how to contact or communicate with the family law facilitator's office. And then remember, you may not get a pretrial conference order. Again, every judicial officer manages their cases a little bit differently from the next. And so if you don't get an order on a pretrial conference, you'll want to follow the deadlines in your case schedule. That's going to control when you need to turn in certain documents to the court file. And I've been referencing a pretrial conference order or PTC as you see here on the slide, but this is an example or at least the cover page of a pretrial conference order. So here, as you see, a pretrial conference order ultimately just sort of summarizes what it is the court is going to be expecting to hear at the trial. So as you see on the screen, the pretrial conference order will detail these are the issues that the judge will need to decide at the family law trial, whether it's child support or a parenting plan or the division of property and debt, or issues of paternity. So all of that is going to be detailed by the judge at a pretrial conference hearing that will be set. And of course, you should get notice of that from your judge so that you can also participate in that pretrial conference order. Some other important deadlines in a pretrial conference order are deadlines of when to turn in certain materials, like say your proposed child support worksheet, so that the court knows what it is you want that judge to sign. The pretrial conference order will also have deadlines about when you need to turn in your evidence or your information that sort of backs up or supports what you want the judge to enter at the trial date. The pretrial conference order will also tell you how to deliver those documents to the court, so pay special attention to all of the content. So you got to read the document, pay attention to all of that information in the pretrial conference order. And it's probably also helpful to you, or could be helpful to you, to write those deadlines on your calendar, physical, or on your mobile phone calendar, so that you don't miss those important deadlines. Next, here in King County Superior Court, the court asks parties to choose the type of family law trial that they want the judge to conduct. And there's two different types, and those two different types are what you see on the screen, be it a traditional trial or an informal trial. A traditional trial, as you see on the screen, is sort of a more formalized trial where rules of evidence or certain rules on how to give information or present information to the court, rules about how to sort of ask certain types of questions. So a very strict, more strict way of conducting a trial is a traditional trial. And so as you see, in terms of some things to summarize about the differences, in a traditional trial, witnesses can testify. So that means that if you have your Aunt Sally, who you want to bring to court to testify in support of the parenting plan that you want the judge to sign, or you want to have a financial expert testify about the value of the assets or the retirement accounts, you can bring those witnesses to testify in court on the court date. When it's your turn to go, you would call that witness and you would ask that witness questions, and they would answer questions from you to the court. In addition, you are asked questions by the other party. So there's sort of, if you're on the witness stand, you can be asked by the opposing party or the opposing party's attorney certain questions similar to what I just detailed before. Now, contrast that with an informal trial. And sort of like the name says, an informal trial is a type of family law trial where the rules are very relaxed. The point of it is that the court knows that a lot of folks who are conducting trials, who are not attorneys, don't conduct trials for a living. And so informal trials is a way that the court can get the information from the parties that it needs from the parties to decide the outcome of the case without having to worry about whether certain rules of evidence were followed completely or not. So again, some of the rules are relaxed. In addition, there's typically no witnesses that are testifying in an informal trial. So again, using my example, if you want to get out Aunt Sally to testify about your parenting plan or to support information about that or how good a parent you are, Aunt Sally wouldn't be allowed to testify on the witness stand in a trial, in an informal type of trial. Rather, Aunt Sally could give a witness statement detailing those things that Aunt Sally has knowledge about. And so those type of declarations are allowed, written declarations are allowed to be submitted to the court by the person in the proceeding, so the petitioner or the respondent, but no witnesses or third-party witnesses are typically allowed in informal trials. The exception to that is guardian ad litems or GALs, as you see on the screen under informal trial under the third bullet, or family court services evaluator. So those are types of parenting plan evaluators. In addition, in an informal trial, the judge is kind of refereeing the show, so to speak. So the judge asks questions of the parties rather than the parties asking questions of witnesses or asking questions of the other party if the other party is on the witness stand, as it would be in a traditional trial. So that's another big difference from an informal trial and a traditional trial. Traditional trial, you as the parties are sort of running the show and sort of presenting the information that you want the court to consider. In an informal trial, the judge themselves are soliciting that information, asking questions, or asking the parties, what types of questions shall I ask of the other party if the judge has asked all of their questions to the parties themselves. So key differences there between the two types of trials. No matter which trial is selected by the parties, the court is going to give you a decision that's going to be expected, or that the court expects you to follow, no matter if it's a traditional or an informal trial. So the decision at the end of either trial has the same impact no matter which trial is chosen. It's just how the trial, again, is conducted. Now, how do you choose the type of trial that you want? Well, the court asks parties to complete a trial selection form and file that form with the clerk's office, selecting whether or not the party who's filing the document wants an informal or a traditional trial. In order to have an informal trial, both parties have to agree, meaning both parties have to check a box on the trial selection form saying that they both want the court to conduct an informal trial. If one party does not agree, then the judge will conduct a traditional trial, meaning if one party checks informal and the other party checks the box on their own form selecting a traditional trial, then the court has to conduct a traditional trial in that case. So again, two parties need to both opt in to informal trial. The link form for the for the trial selection, the trial selection form link will be in the description box, as will a lot of the forms that I'm referencing here in this video. So be sure to access that by just clicking that link so you can obtain the trial selection form from the King County website. Now, let's talk a little bit more in detail about preparing for a traditional trial. So as I mentioned in the first part of this video, when the judge conducts a pretrial conference order, typically you will get deadlines to turn in certain documents. And those certain documents are a witness list. So a list detailing the witnesses that the parties are going to call to testify at the traditional trial in person or on video. The pretrial conference order will also have a deadline of when the parties need to complete an exhibit list, which is typically a list of the documents that the court or that a party wants the court to look at while the judicial officer or the judge is listening to the trial and making a decision after the trial. And then another type of form that the court typically will require and put a deadline for in the pretrial conference order is a financial declaration and other types of financial records required by our local family law rule 10. We'll have a link below this video for local family law rule 10, so you can take a look at what is required of you in that type or in that rule. Remember, when you are turning in the documents to the court by the deadline in your pretrial conference order, you're also required to turn in these same documents to the other parties in the case. And those other parties include if you have a guardian ad litem assigned to work on your case, or to the family support unit if child support is both an issue in the case and the child or children in the case receive some form of state assistance, typically in the form of cash payments like TANF. So that is also required of the parties to turn in documents to those third parties if folks that I just mentioned, GAL's child support unit, are involved in your family law case. Now, the witness list that I just alluded to, you have an example here on the screen. Now, just a heads up, we have a template as well as other trial materials that you're going to see here in the video under the description box with a link so you can access these forms yourself. But the witness list or a witness list is what you see on the screen. This is just a template to give you some information on what goes into it. So on the witness list, you see the caption where you're going to put the petitioner's name or the person who initially started the case, as well as the respondent's name and the case number. And then on the witness list, you're going to write the name of the witnesses who are going to testify at the traditional trial in support of whatever you're asking the court for. Provide their contact information, so their address, their phone number, and then briefly describe what it is that they're going to talk about. So for instance, using my tired example of Aunt Sally, if Aunt Sally is going to testify in terms of the parenting ability of Jane Doe, the petitioner, then that's what you can put in that box about the summary of knowledge or expertise. They will testify, or Aunt Sally will testify about the parenting ability of petitioner Jane Doe. So make sure you detail that for each witness that you're going to have testify at the traditional trial. One thing to keep in mind is that you do not have to have 10 witnesses, for example, that are going to say the same thing at your trial. It's not as if more is better. So you want to think about who has the best information or who is the person or the witness that you think has the best personal knowledge about the actual thing or concept or issue that you want the court to actually make a decision about, and then list a person or two that can testify to that specific event or that specific issue that you think is relevant to the court. Also, friends and family members typically cannot provide opinions. So when I say, again, choose the person that you think will have the best information to give to the court or best personal knowledge, that usually doesn't include someone's own personal opinion, but what they've observed with respect to the issue that you're bringing that witness in front of the court to testify about. Now, an exhibit list. An exhibit list, as I mentioned before, is just a list of all the documents that you want the court to look at to support what it is you want the court to make a decision on at your trial. So on the exhibit list, make sure you gather all the documents and the evidence that you want the judge to see. It's not the judge's responsibility to guess and think from your case file, even if you filed these things. It's not the judge's responsibility to guess what those documents are that you want the judge to see at your trial. So tell the court what it is they should look at and provide that information to the court. Again, when you are representing yourself, you're standing in the shoes of your own attorney. So make sure you advocate for yourself and don't leave any stone unturned with respect to what you want the judge to look at. Name that exhibit, list it. If you're the person that started the court case, you typically start your list of exhibits at number 1. If you did not start the current court case that you're involved with here at King County, then your exhibits typically start at number 100. But again, make sure you look at your order from pretrial conference, because that will be sort of that overall guide that will tell you what you start or how you label and list and number your exhibits. A few things to keep in mind. Court staff can't tell you what evidence you should provide. So if you have questions, say, of our family law facilitators about what's the best information to show the court, we as court staff can't tell you that. Rather, we can tell you just generally, what folks provide or what under, say, local family law rule 10, the required financial documents in terms of exhibits, like tax returns and 6 months of bank statements and things that our rules outline for you, but we can't tell you what you need to have as an exhibit. It's up to you. It's your case. You decide what you think is a relevant exhibit to the court to aid it in making its decision. So make a list of what you want. That's the exhibit list. And then think about the facts that you need to show the judge. And again, what information that you can gather that helps the court make that decision for you. So that's ultimately how you come up with your exhibit list. Again, just like other forms, the witness list that we just talked about, the exhibit list also is typically required by the court for you to file a copy or deliver a copy to the court, to the judge, and then give copies to the other parties that are involved in your case. So be sure to remember to do that. Now, a few terms or phrases to know at trial. We've talked a little bit about evidence, and so you have a definition there that you can take a snapshot of on the screen. There's also a definition for some other relevant things, and this is not an exhaustive list, of course, with these 5 things listed, but here's some common things that you want to at least be aware of. Evidence Rule 904, the last bullet that you see on the screen, that's a Washington State court rule that basically allows parties to provide their disclosed evidence or proposed evidence if they give notice to the other party in enough time, then those documents are automatically admissible or automatically accepted by the court at the traditional trial if that rule is strictly followed in terms of the timeliness of notice and how it's given, and that there's no objection or the other party doesn't say, no, this exhibit or this document should not be allowed because of X, Y, and Z. So I want to point that out just so that you know that at a traditional trial, as I mentioned, there's certain rules to follow about how to present evidence and how to admit evidence. And so this rule talks about how certain documents that you present at a traditional trial can be automatically admitted, which saves you a step, at your traditional trial if that rule is strictly followed. We have a link below to Washington State Courts, a court guide to some other terms that you may find helpful. And there's also some rules below, or excuse me, a link below with respect to some evidence rules that you may want to talk about, as well as a general resource list should you want to speak with an attorney about more details about this rule and how it can relate to your case. Check out that general family law resource list for a guide about legal resources and free or low fee consultations throughout King County to talk with a professional more in detail. Here, let's talk about financial declaration. I've alluded to this before when I talked about local family law rule 10. A financial declaration is typically required whenever the court needs to decide about issues that deal with money. So for instance, child support or spousal support or dividing any debts, then the court under local family law rule 10 typically requires the document that you see on the screen. On the financial declaration, you want to do your best to answer the questions in there. Okay, perfection is not the goal. You want to do your best to try to complete what you believe the other party's gross monthly income is. If you don't know it, then do your best to try to figure that out based on the information accessible to you. In addition, the financial declaration also has sections where you're going to detail for the court basically what your monthly budget looks like in the sense of the expenses that you expend for your gas or your housing cost, mortgage or rent, as well as other installment debts or other debts in general that you may have. So again, do your best to estimate those monthly expenses, and then at the end of the form, you're going to sign under the penalty of perjury saying that you did your best to estimate those monthly expenses in the financial declaration. I've mentioned local family law rule 10 a few times now. What you can see on the screen is not an exhaustive list of the documents that are required under that rule, but you can take a look at what the court expects of you, so you can get a sense of the information that you need to gather from the court whenever the court needs to make a decision about finances. So try to prepare those materials as best as you can in advance, so you're not blindsided when the court in its pretrial conference or order on pretrial conference informs you that you need to submit local family law rule 10 documents. So you see some of those on the screen. Again, the other party needs to be served with whatever the order on pretrial conference tells you you need to give to the court. And so if there is a concern that you disclosing certain account numbers, or if a financial record that you have, like your tax return, of course, has your income, or excuse me, your social security number or an EIN number if it's with respect to your business. If you have concern about your personal safety or that it could be jeopardized by disclosing that information to the other party, please seek legal advice. And a great jump off point to seek legal advice is that general family law resource list with the link in the description box, so you can obtain some information from a professional about what you can do. Next, in cases without children, you're typically going to be required to complete a form titled a joint confirmation regarding trial readiness. That form, sort of similar to a pretrial or an order on pretrial conference order, that's going to indicate certain deadlines of when you need to turn in materials to show the court or show your judge that you are ready for your trial. Once you complete the form, then you're going to want to file a copy with the clerk's office and serve the other party with a copy of that form by the deadline in your case schedule. We have a link in the description box for where you can obtain that form so you can get that in advance. Also, you're going to want to take a copy of that form or send a copy of that form to your assigned judge. Your assigned judge is typically on the case schedule that, if you are the one that filed the case or you're not the one that filed the case and you were served with the case schedule, your assigned judge is typically on the first page of your order setting the domestic case schedule. Now, with respect to some traditional trial materials for the judge, your pretrial conference order, or the formal name, your order on pretrial conference, is going to detail a lot of this information. Your proposed orders, what you see, or excuse me, typically 1 week before trial, the judge is, let me back up, the judge is going to want to receive a copy of the documents that we talked about, the witness list, the exhibit list, financial declaration, and then local family law rule 10 documents. Your order on pretrial conference is going to probably tell you how the court wants you to upload those forms to a system called ShareFile. There's going to be a link in the description about ShareFile and what it is. But again, pay attention to your pretrial conference order so that you can have that information about how you get those trial materials to the judge. And now, proposed orders. I was a little bit ahead of myself. So a few more trial materials for the judge that will be indicated in your order on pretrial conference is the requirement to, at least 1 week before your trial, email the judge proposed final orders. And those typically are required in Word, so that if the court needs to amend certain things about what you put in your Word versions of the orders, they can do that, as opposed to it being a PDF and them not being able to do that. So your proposed orders are documents required to finalize the case. So there's a link in the description box below to a cheat sheet that lists the final orders for each case type. So if you're filing a divorce, there's certain final orders that you need to finalize your case at trial, which are a little bit different than the final orders that you need to finalize in, say, a parenting plan case where you and the other party may not be married and are not getting a divorce. So take a look at that cheat sheet. All the forms also are on the Washington State Court website. So we also have a link to that description. Either one will give you an idea of what type of final orders you need for your particular case type. Now, in terms of preparing for an informal trial, so moving from a traditional trial to preparing for an informal trial, the order on pretrial conference that you may receive will provide the specific instructions on what's required for you to do, or required for you to do in an informal trial. LFLR 23, which references local family law rule 23, details the things that are typically required, so you can get a jump start on just simply doing an internet search of that rule to list or to see the list of what an informal trial process looks like, as well as what's required. But again, your order on pretrial conference order will typically have that for you as well. What you generally need to prepare in an informal trial is a lot of the same things that we talked about for a traditional trial, except you don't need a witness list. Again, in an informal trial, witnesses don't come to court or aren't available for the video trial if the court tells you that the trial will be video or by video. Rather, witness statements are allowed in an informal trial. So those will be included as exhibits. And again, a reminder, make sure that whatever documents you give to the court in preparation for your informal trial, you also deliver copies to all the other parties involved in your family law case. Typically, 1 week before trial, you're going to want to give your judge a copy of your trial materials, which generally include an exhibit list with a copy of each exhibit. So the list of documents plus the documents referenced in there. So the declarations from Aunt Sally and other people, your local family law rule 10 financial documents, your financial declaration, and your proposed final orders in Word version. You'll also use ShareFile. That's usually indicated in your pretrial conference order on how to do that. Again, link in the description for more information on how to upload forms into the ShareFile online cloud for the court for your particular trial. And one additional plug, you need to request a link at least 2 weeks before trial. If you have questions about ShareFile, if this is relevant to you and you're at the point where you need to upload documents and you keep hearing this term about share file, definitely check with the family law facilitators for some more information. Or again, take a look at the link in the description about share file and how to upload documents into that cloud system. So rounding out the video here, a few tips for trial prep. We've talked a lot in detail about the materials that you need to gather, the witnesses that you may need to prepare if you're doing a traditional trial. And so the big takeaway is that if you and the other party do not have an agreement in your case and your trial date is approaching, start preparing early for your trial in terms of gathering information. And one common theme throughout is get legal advice. So legal advice, or we have a description in the link to the general legal resource list for legal advice. Our family law facilitators here in the court cannot give legal advice, rather general information about the rules and what's expected of you based on the court rules, like local family law rule 10 or like your order on pretrial conference, but staff can't give you legal advice. So definitely speak with an attorney for customized legal advice about your situation. And then instructions and forms, they're available online for free to the public. Resources that I mentioned are in the description box below this video. And again, facilitators are available to answer general trial prep questions. They cannot provide legal advice again, but they can answer the questions about the steps that you need to take. Link in the description. Thanks so much for watching this video. I know it's a lot. Do something fun now that you got a crash course into trial, and I'll see you in the next one. Thanks.